Heyo, folks. Heyo, folks. Welcome. This showed up not even an hour ago, I think. Judge Gildea, or, well, Uncle Bev, or whatever you might call him, has denied both Karen Reed's and Aidan Kearney's motion to dismiss due to the anti-Slapp. Now, it will be interesting. Now, I'm not surprised. I'm not. But it's still interesting to see if there are any major flaws in his decision that the defense of both Karen and Aidan we can actually attack this. Now, again, even if they take this further, I would have a hard time seeing even an appeal or a reconsideration or stuff like that going through. But it's still interesting to see where we land. So, folks, welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Ho, 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 raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses. Santa Claus, Santa Claus, Santa Claus, Santa Claus.
All right, let's get this thing up here. Oh, but hello, folks. Hello. Yeah, it's Friday. Later today, in about 3 hours, it is Slightly Buzzed Show. And I have an exciting, all-new guest. Bacon Bears will join me and others this evening or afternoon on the Slightly Buzzed Show. So that will be really, really interesting. All right. Without further ado, hold on. Oop. Let's go through this and see what we can find. And hello, folks. Hello, Lang. Hello, Skillerpan, Welshie, Nexus, Denise, Kitty Cat. Oh, Kitty Cat. Zenit, Christine, and hello, you guys over at Rumble. Hello, folks. Good to have you here. Good to have you here. Yeah, at the end of this stream, you will be automatically transferred over to the Slightly Buzzed Show. All right. Let's go ahead. Commonwealth of Massachusetts, Plymouth Superior Court Civil Action number yada yada yada, Jennifer McCabe and others versus Karen Reed and another. Memorandum of decision and order on defendants. Special motions to dismiss pursuant to the anti-Slapp law. Plaintiffs Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins, who doesn't like to call themselves, that we call them house defendants. So on this channel, we have dubbed them to the Wankers. Let's see if they like that more. Hi, Anima Rampir over at Rumble. Hello. Brought this action against defendants Karen Reed and Aidan Kearney, and misspell of name, alleging they conspired to defame them by falsely stating they were responsible for the death of Reed's boyfriend, John O'Keefe. The First Amendment complaint asserts claims against both defendants for defamation, intentional and negligent infliction of emotional distress, and civil conspiracy. Yeah, for you who might not know, at this early stage, because it is actually, despite Judge Gildea's efforts, this is one of the first steps in civil suits, trying to get rid of it, nip it in the bud. But the judge has to assume what the plaintiffs are saying are true. And in the anti-Slapp, the defendants have to show to the judge that the plaintiffs does not even reach that low of a bar. So, hence, I'm not surprised. Blah, blah, blah. The plaintiffs also assert separate claims against Reed for aiding and abetting Kearney in Kearney's defamation and infliction of emotional distress against Kearney and against Kearney for violation of GL, blah, blah, blah. The defendants have each filed a special motion to dismiss pursuant to the Anti-Slapp statute. For the following reasons, the motions are denied. Okay, so right out of the button, this judge doesn't. This is my decision, and then here is the discussion. The Anti-Slapp statute, quote, establishes a procedure for obtaining the early dismissal of a claim that seeks to impose liability on individuals for exercising their constitutional right of petition. Let's see, I'm quoting Bristol Asphalt versus Rochester, blah, blah, blah. These powerful procedural protections were intended to be employed in a limited context to ensure that the expeditious elimination of meritless lawsuits based on petitioning activities alone. However, the statute has been regularly invoked in attempts to dismiss a wide array of other claims concerning conduct far afield of the petitioning activity that the legislators originally sought to protect. Quote, to ensure that a special motion upon its own petitioning activity is not infringed by the allowance of a special motion to dismiss, the Supreme Judicial Court has adopted a two-stage burden-shifting framework for analyzing the merits of a special motion to dismiss filed under this. Also, Allegiant versus Harbor View Hotel Owner LLC. Hopefully, I don't have to fact check the judge's case law. I've learned that I have to do it when it comes to the plaintiff's attorneys, because they seem to use what do you call it? They are very liberal with the truth when it comes to their filings. To prevent the special motion to dismiss and the powerful procedural protections they afford to litigants from being misused to quell petitioning activity, our jurisprudence has adopted a necessarily narrow and strict construction of the statute. A party seeking dismissal under the Anti-Slapp statute must, quote, make a threshold showing through the pleadings and affidavits that the claims against it are based on the party's petitioning activities alone and have no substantial basis other than or in addition to the petitioning activities. Again, resorting to Bristol Asphalt. If the special motion proponent cannot make this threshold showing, the motion is denied and the challenge claim survives. However, if the special motion proponent is able to make the threshold showing, the motion will be allowed unless the non-moving party demonstrates that the petitioning activity was, quote, devoid of any reasonable factual support or any arguable basis in law, and caused the non-moving party actual injury. This here seems copy-pasted. Because looking at this entire first part of the discussion, there's no reference to neither Karen or Aidan. So, copy-pasted. Not entirely bad, but shows me a bit of lack of imagination on the judge's part, which sometimes is good, sometimes is bad. As noted, the defendants have separately filed special motions to dismiss under the Anti-Slapp statute, and therefore they each have the initial burden of showing that the claims against them are based on their petitioning activities alone and have no substantial basis other than or in addition to those petitioning activities. Petitioning activity under 59H includes any written or oral statement made before or submitted to a legislative, executive, or judicial body, or any other governmental proceeding. 2. Any written or oral statement made in connection with an issue under consideration or review by a legislative, executive, or judicial body, or any other governmental proceeding. 3. Any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, or any other governmental proceeding. 4. Any statement reasonably likely to enlist public participating in an effort to effect such consideration. And that is Aidan Kearney's main argument in his anti-Slapp. And a statement reasonably likely to enlist public participation in an effort to effect such consideration. And folks, there are literal, in the Free Can Read movement, literal hundreds of thousands of people who would not have been there if not for Aidan Kearney's reporting. So, what here in petitioning activity does the judge say that Aidan Kearney didn't do? Or 5, any other statement falling within constitutional protection of the right to petition government. And for me, Aidan's argument here is the strongest of the two motions, because there is a clear argument that without Aidan Kearney's reporting, the FBI might not have been involved. There is clear to me, at least, that without Aidan Kearney, the Free Can Read movement would not have existed, not in the form it is today. There are lots of people who claim, oh, we were there before him, and not a single one of them can show a single link to something they said prior to Aidan's reporting. None of them. Isn't that weird? But that's the antis. They love to lie and create new accounts claiming the same things over and over and over again, because the rest of us, we so easily debunk what their claims are. So they have to block, delete, repeat. The court concludes that neither defendant has made the threshold showing under the statute. Okay. Let's see what his arguments are here. Defendant Kearney's initial burden. The plaintiff asserts claims against Kearney for defamation, intentional and negligent infliction of emotional distress, civil conspiracy and violation of this. As explained below, Kearney has failed to satisfy his initial burden for 2 reasons. Okay. First, the claims have a substantial basis other than petitioning activity. Yep, that's not the so the judge here is saying substantial basis other than petitioning activity. So the claim here from the judge is he doesn't care if it has petitioning activity, because he said it to more than the government. He addressed the public. That's a very, very strange argument for me. Does the judge claim that claims has failed to repose the claims have a substantial basis other than petitioning activity? So that would mean that if you wrote an article, let's say, for instance, let's say I am an absolutely deranged woman who likes Nazi cops. Let's call me Fetchen Moss. And I write an article to the public. Let's say in there it's various allegations. Wouldn't that as well be exactly like the judge is claiming here? That this imaginary person named Fetchen Moss is committing defamation under the guise of the First Amendment. Because that is practically what the judge says here, that yes, Aidan Kearney, petition the government, petition the court, petition the police to do your damn job, do a damn investigation, stop hiding evidence, stop lying. But since he addressed the public, the judge seems to say, well, then it's no longer petitioning the government. Then says, second, even if this were not the case, the FAC alleges that he was not engaging in petitioning activity on his own behalf, but rather on behalf of Reed. Isn't that what journalists and reporters do? Isn't that what I do? Melanie does? Andrea does? Ian does? Mo does? When we do this, rarely it's on our own behalf. That's called reporting. I'm using the medium of YouTube, Rumble, X to try to right a wrong. According to this judge, it seems like, nah, that doesn't count. Because you're not doing it for yourself, you're doing it for another. Fucker! If you don't fight for free speech for others, only for yourself, you're not fighting for free speech at all. Okay. I didn't expect to be pissed off this early. And hello, Shelley B over at Rumble. Hello. Other substantial basis. Okay. Kearney argues that the plaintiff's claims seek to hold him liable for petitioning activity because his statements fall under the second, third, and fourth clauses of this. However, he has failed to establish that this is the cause. Okay. It seems like the judge has the opinion first and the reasoning after. Let's see here. Defamation claim. The defamation claim is primarily based on Kearney's repeated statements accusing the plaintiffs of murdering O'Keefe and covering it up. Kearney's first argues that by publicly accusing the plaintiffs of murder, his statements were reasonably likely to encourage consideration or review of O'Keefe's death by an executive body. Yeah. What Aidan was doing was look at the damn evidence and what they actually tell us. The evidence before the trials even started pointed at the wankers or the House defendants, however you want to call them. The evidence, once scrutinized, never pointed at Karen Read. Never. Now, you might not like Aidan's wordings, but the effect of the words was that it brought this corrupt, Nazi-stricken Massachusetts State Police and Canton PD. It brought their everything up to into the sunlight, and it burst. That is the actual effect of it. However, of all the various places Kearney made his statements on his live stream, social media platforms, his blog, on plaintiff's voicemails at the plaintiff's homes, and in the case of McCabe at her daughter's lacrosse. Oh, for fuck's sake. None were to an executive body as a part of a judicial or other proceeding, or to any authority that could affect the consideration of the issue. You fucking... Let's go up here. Here, number 4. Any statement reasonably likely to enlist public participation in an effort to effect such consideration. There it is. In black and white from the legislature and the courts. Where were we? So this, now, the quote Faber versus Walton, quote, filing of a complaint from an abuse protection order and the submission of supporting affidavits are petitioning activities. Dever reward, defense appeals to the police and to the courts were quintessential petitioning activities. O'Gara, reporting suspected criminal activity to the police was petition activity. Here's the thing. Problem here is that the police, the prosecution, was a part of the cover-up. Knowingly or unknowingly, but willingly. Hence, the petition had to be larger. This judge here is making excuses for police corruption, in my opinion. Kearney cites no case law suggesting that statements to other members of the public accusing someone of murder qualify under this clause of the Anti-Slapp statute. Such statements lack this application to higher authority, which should have rendered a de novo analysis. Since people in the house was law enforcement or had been law enforcement or married to law enforcement, friends, kid, etc. And when you have the situation when the corruption of the police, corruption of the DA's office is at the center, as I said before, you have to make it broader. Kearney next argues his statement of petitioning activity because they were made in connection with an issue under consideration or review by legislative, executive, or judicial body, namely the investigation into John O'Keefe's death and the prosecution of Karen Read. The SGC has stated that for a statement to qualify under this clause of the Anti-Slapp statute, there must be, quote, a plausible nexus between the statement and the governmental proceeding. He addressed the corrupt investigation, bringing corruption to the masses, showing corruption to the masses. Because in this case, the governmental proceeding was the problem. That is the nexus between the statement and the governmental proceeding. But the judge says, nah, no nexus. No nexus. And he quotes Blanchard v. Stewart, to assess if this plausible nexus exists, the analysis objective indicia of a party's intent to influence a governmental proceeding, such as the timing, audience, and content of the statement. Yeah. The communication must be closely and rationally related to the governmental proceedings. Yeah. And made to influence, inform, or at the very least reach government bodies either directly or indirectly. How is this negative to Aidan? How do the no. 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 Although some of Kearney's statement at least tangentially relate to an issue that was under judicial review, i.e. the prosecution of Karen Reid, the claims largely target statements that do not have a plausible nexus to this prosecution. How? How? The statements are directed toward viewers and potential viewers of Kearney's live stream and readers of his blog, and their content does not seek to influence government action in any way. What? This is we are getting close to a cork on fork stupidity here. How, folks, how do you influence politicians? By gathering a lot of people, especially like as in this case, the Karen Reid case, when the government is the problem. Mispronounced name. Bold of you to assume Massachusetts knows how to operate a cork. My apologies. Yeah, good point. He definitely reached government bodies. Just look at the hostage video. Yeah. As a direct result of Aidan Kearney's reporting, D.A. Morrissey recorded, what was it, 5-6 minutes of provable lies to try to counter Aidan Kearney. So apparently he influenced the government. Thanks, mispronounced name. Yeah, that's it. Yeah, hostage video, Exhibit 1. Quotes Lucy versus Kinnon, post not directed to the government that did not mention any government proceeding, but rather consisted of throwing barbs at another, was not petitioning activity. Aidan, I watched a bunch of his videos, and to my understanding, to my knowledge, if I'm wrong, please correct me. In every stream, he mentioned the corruption in the police. He mentioned the corruption in the DA's office. He mentioned the flaws in the investigation in every damn stream. Rather, the statements are aimed at convincing Kearney's audience to regard and treat the plaintiffs as murderers. Oh no! Aidan asked people to look at the evidence. Mind blown! Absolutely mind-blowing. That a reporter asking his audience to look at the evidence and look at the evidence for corruption, planting evidence by the state police. Imagine that. Fuck's sake. Quoting here. Jennifer McCabe and Brian Albert are involved. They are covering it up. ... The McCabes have the look of evil in them when you see them in person. These are people with no shame and aren't the least bit deterred by the fact that millions of people know that they participated in a murder and subsequent cover-up of a murder of a Boston police officer. That's what the evidence showed. Jen and Matt McCabe do not deserve to live a normal life and pretend that they weren't involved in murdering a Boston police officer. Because that's what the evidence showed. Calling McCabe a cop-killing pig. Felony murder. You don't have to pull the trigger yourself. Such statements are markedly different than those that courts have concluded are made in connection with a proceeding under judicial or executive review. Let's go up here again. Number 4, any statement reasonably likely to enlist public participation in an effort to effect such consideration. It's right there, Judge. It's right fucking there. Now, where were we? Oh. Where are we here? To be sure, the wanker cites many statements that were reasonably likely to enlist Kearney's audience to share his opinion and make that opinion known to the plaintiffs and other members of the public. Here's the thing when you cut out statements, is that in Aidan's 2 to 5 hour streams, there was a lot more than these statements. But the judge refuses to look. And here's something that the antis love to say. Look at the whole picture. But they never, once we go into details, they refuse this. Oh, you have to look at the big picture. Well, how about you guys and this judge look at the whole picture? Because the only way you get to the whole picture is by looking at the details. That's the only way. There's no whole picture if the shutter is closed. Okay? Nothing but hatred to McCabe, as I should, because I'm normal. I'm a rational person. And a rational person hates Jen McCabe and is disgusted by her because Jennifer McCabe is a pig. She's a pig. She's a cop-killing pig. Felony murder. Aiding a person in a in a murder can get you a felony murder conviction. Responded to claim by McCabe's friend that she was harassed by Kearney's supporter in public. Kearney stated, the fact that Jennifer McCabe has to cover her face in public like this because everywhere she goes, people immediately see her face and recognize her as a cop killer. It's a great thing. Because we looked at the evidence. Okay, here we have a footnote. For instance, Kearney does not explain how his enlistment of 200 individuals to participate in a rolling rally to go at the plaintiffs' homes while he shouted into a bullhorn that Brian Albert and McCabe were covering up John O'Keefe's murder was reasonably likely to enlist public participation. Judge, you're a moron. The fact that he got 200 people is enlist public participation in an effort to affect consideration by an executive or judicial body. You're saying it out loud, Judge. You're saying it out loud, but you completely miss it. Yada, yada, yada. They're right fucking there walking around like nothing happened. What are you going to do about it, huh? You're going to ask them anything? You're going to talk to them? You're not in this for being uncomfortable or making, people who committed horrified crimes uncomfortable. However, for such statement to be protected petitioning activity, they must be, quote, reasonably likely to enlist public participation in an effort to effect, i.e. bring about governmental consideration of an issue. And it fucking did. It did. Just look at all of us. Just look at all of us. Folks, here's a direct thing that happened because of this. Adam Deach left the best job he has ever had to become a prosecutor in Norfolk County. How's that? Public participation in an effort to bring about governmental consideration of an issue. That you guys made Adam Deach leave his cozy favorite job for the unthankful, ungrateful job as a DA to try to be the next DA of Norfolk. How's that? Just look at what actually happened, Judge. Just look at what actually happened. Now, I wish that Aidan or Karen Reed brought that up, what actually happened as a direct result of this effort of Aidan, because it's all there. Let's continue. The statements that are the subject of the defamation claim clearly are not. Okay. And he quotes Global Naps. Anti-Slapp law, quote, does not protect tangential statement intended at most to influence public opinion in a general way unrelated to government involvement. Huh? Unrelated to governmental involvement. According to this judge, making the public aware of governmental corruption, because that's the issue here. If Aidan just went to the cops and said, hey, here's my opinion about this case, nothing would have happened. To get the government's attention, you have to be loud and you have to be many. And what happened? The government got involved. Blah, blah, blah. Website designed to disseminate to the public information about plaintiffs to attract clients to defendants' law practice was not reasonably likely to enlist public participation in an effort to effect such consideration. In the Kale versus Schlichtman, there's a whole lot more here, Judge. There's a whole lot more. Aidan was out in public. He had his website. He had YouTube. He had every damn way he could affect the government. He did. Hi, Dave. Yeah, this will surely be appealed. Yeah, other claims. Kearney's motion as to the plaintiff's other claims for intentional and negligent infliction of emotional distress, civil conspiracy, and Chapter 93A similarly fails because the claims are clearly not based solely on petitioning activity. Here's the judge ignoring what actually happened. This type of argument from the judge puts every reporter at risk for reporting. For instance, like the completely imaginary person, Machen Foss, who by hypothetically spewed out things that are provably wrong and things that not even the prosecution claimed, hypothetically, because of course Fetch and Moss is an imaginary character, is a hypothetical. By the judge. Now, I don't give a shit if this hypothetical reporter in an imaginary magazine from Boston, it's easily debunked if that hypothetical scenario ever existed. But if somebody, they could take these exact words from the judge and this imaginary Fetch and Moss in a magazine out of Boston spewing shit, crap, and everything, that imaginary person would be absolutely fucked by just using this judge's words against Aidan Kearney. Other claims. These claims go beyond Kearney's statements calling the plaintiffs murderers, which, as explained above, are themselves primarily not petitioning activity. They are. And seek redress for his actions purportedly organizing the rolling rally mentioned above, publicly releasing the plaintiff's personal identifying information. They themselves did that. And the DA's office. Harassing the plaintiffs and the family members and encouraging others to do the same. False. Conspiring with Reed to cover up a crime by wrongfully accusing the plaintiffs and operating a commercial enterprise selling merchandise featuring the plaintiffs' names and likeness. As to these claims, Kearney also has clearly not satisfied his initial burden, and therefore the motion must be denied. Yeah, okay. So that was... seriously, Judge, your opinion here puts any reporter in Massachusetts at risk. This is the judge outlawing opinions. B. Petitioning in one's own right. Even if Kearney's conduct, that is the subject of the challenge claims, could be considered petitioning activity, his motion fails for an additional reason. The Anti-Slapp statute provides that a special motion may be brought for claims against a party that, quote, are based on said party's exercise of its rights of petition under the Constitution. That phrase is read as, quote, as restricting the statute's coverage to those defendants who petition the government on their own behalf. What? If that statute is correct, it is absolutely stupid. Because that would render that could make any politician tell their opposition, you're not you are supporting my opposition, but it's not on your own behalf. It's stupid. If that statute actually is that, it's stupid. The statute is designed to protect overtures to the government by parties petitioning in their status as citizens. Although the party bringing the special motion need not be the beneficiary of the particular cause the party seeks to advance, protections of the statute are limited to those who engage in petitioning activity in their own right. When it comes to government corruption, we are all petitioning both in our own right and the person affected, directly affected. In the Cardinal Kamrisk, blah blah blah. Here, the wankers alleges that Kearney was not speaking on his own behalf, but rather on behalf of Reed. The wankers alleges that Reed found and enlisted Kearney, this is so stupid, to publicize a story about the plaintiffs, and that Kearney agreed to and did publicize and widely disseminate Reed's false claims about the plaintiffs and others in an effort to destroy the reputations of these individuals so that Reed could evade responsibility for causing the death of John O'Keefe. Now, again, here we go back to the judge, what the judge has to do. He has to regard the plaintiff's words as true. That's, in this initial stage, that is what he has to do. It seems like he goes a little bit further than that, in my opinion. Yeah. As Dave says, not since Larry Flint there be a more compelling Supreme Court opinion than in Turtle Boy v. Massachusetts. Yeah. If you don't know Larry Flint, he was the owner of Hustler magazine, which was a soft-core type of magazine, who sometimes reported on and made a mockery out of politicians. And one of these politicians, who was especially weak, sued Larry Flint. Now, Larry Flint, well, that went all the way up to the Supreme Court. And the Supreme Court said, yeah, fuck you, politician. Basically that. There's a movie, The People versus Larry Flint. It's from, it must be 25 years old by now. But it's a very good movie. I suggest you watch it. It further alleges Kearney acted on behalf of Reed in publishing defamatory statements about the plaintiffs to assist Reed in her trial, and that Kearney used information in his blog post which Reed funneled to him with knowledge that he would publish it on her behalf. Or imagine this. Court documents. Oh! Court documents public? No! You can make opinions out of dissecting court documents? No. That never happens. That people in the world read court documents and make their opinions on those. In stark contrast to the allegations in the Wankers motion, Kearney characterizes his statements as an effort to raise awareness about police corruption. Yeah, which he contends is his long-standing cause. He argues that much like the defendants in Cardinal Kamrisk, he was petitioning on his own behalf as an activist and a citizen. In that case, the concluded that environmentalists sued for defamation based on statement made in the Huffington Post criticizing a scientific consulting firm that purportedly defended polluters were engaging in petitioning activity because they expressed their own opinions, were speaking for themselves, and at their own behest. Kearney's comparisons to the defendants in Cardinal Kamrisk misses the mark. I don't see how... No. The statements that are subject of the plaintiff's claims in this case have nothing to do with police corruption. What did you just write? What did you just write? The statements that are the subject of the plaintiff's claims in this case have nothing to do with police corruption. This might be the single most moronic I have read in a long time. The statements are everything about police corruption. Because if the police had done their job that morning, if they had went into the house, if they hadn't allowed the wankers to get their story straight, tell them the guy never went into the house. Remember that? Remember that? This is everything about police corruption, because it's showing how the police and the DA's office protected the guys formerly known as the House defendants, or as I call them, the wankers, and keeps protecting them to this day. That's probably the single most moronic thing in this. So this far, yeah, pin it on the girl. If there was no police corruption, Karen would not have been arrested and tried. Yeah. They do not seek to hold Kearney liable for accusing public official of a corrupt failure to investigate the plaintiffs for the killing of Officer John O'Keefe, as Kearney contends. Rather, it cites Kearney's repeated accusations that the plaintiffs are cop killers and murderers who lied about what happened to O'Keefe, which they did. Given the content of the statements, it is more than a stretch to conclude that they were in furtherance of advancing Kearney's stated cause. No, it isn't. Moreover, while Kearney's affidavit states that he wrote his blog post on his own and Reed did not funnel in information, it does not refute the allegations that Reed enlisted Kearney to publicize her story and that he did so to assist in her trial. If the story is true, and a good reporter anywhere, because it's not illegal for a defendant to talk to journalists. Did you know that? It's actually not illegal. Now, a judge might try to throw gag orders around, making it that way, which actually does happen. But that wasn't the case here. There's nothing illegal for a defendant to talk to a journalist. Nothing. And Aidan checked the story with the official court papers. Always checked the story. Thus, unlike the defendants in Kearney has not shown that he was speaking for himself and at his own behest. While the Anti-Slapp statute provides very broad protection for petitioning activities, it was intended to protect the right to petition the government for the redress of grievances guaranteed by the United States Constitution. Where there is no reasonable basis to conclude that Kearney's statements and conduct at issues in the plaintiff's claims were in an effort to petition the government for redress of harm, Kearney has not carried his threshold burden. He made D.A. Morrissey record a video. The hostage video. That is a direct result of Aidan's reporting. That is petitioning the government, and the government reacted. Defendant Reed's initial burden. The plaintiffs assert claims against Reed for defamation, intentional and negligent infliction of emotional distress, blah, 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 blah. Defamation case. Reed's motion cites a handful of allegedly false statements she made about the plaintiffs, which she contends forms the basis of the defamation claim and fall under all 5 categories of petitioning activity under 59H. Her motion, however, neglects to address many allegedly defamatory statements which form a substantial basis of the plaintiff's defamation claim, which cannot be characterized as petitioning activity. Here, the judge make the nexus that whatever Kearney said was on direction from Reed, which, in my opinion, the wankers have not shown in one single bit. For instance, they alleged during Reed's first trial, she had a documentary filmmaker, Terry Moore, record the trial preparation, which included conducted recording interviews with Reed over the course of the trial. During an April 30 interview, Reed stated that Jen McCabe is a first-degree murderer and she knows it, that the plaintiffs know they killed John, and the plaintiffs are murderers, and they know it. Did you just see that, Judge? She had a documentary filmmaker record the trial preparation, which we are on page 11. Let's go up to, where is it? There it is. Any other statement falling within constitutional protection of the right to petition government. Any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body or any other governmental proceeding. Any statement reasonably likely to enlist public participation in an effort to effect such consideration. Yeah. She was in trial preparation. She made this documentary to get her story out. To the public and to the government. Or page 11, right? The wankers also alleged that during an interview on June 15, Reed told Murrer and the team that Brian Higgins, Brian Abbott, and Colin Abbott had a motive to kill O'Keefe, and that during another interview on June 22nd, Reed told the filmmakers, I know Brian Higgins had a role in helping kill him, help him get in the snow and help frame me, but I don't think Higgins necessarily would have wanted to really hurt John. I think Brian Abbott and Colin Abbott would have enjoyed roughing John up. All of that based on the evidence. All of that based on the evidence. Because remember, who destroyed their phones? Who repeatedly lied to the court? What did Brian Higgins say about where he was that night? And when the video resurfaced of what he actually were, at what time and what he did, he lied to the court. Same with Jen McCabe. She lied to the court. She claimed in the first trial that as she was looking out the window as she claimed, you go check it, first trial, as she looked out the window, she noticed the time was 12:41, and she saw Reed's car. We know that is provably false because Karen Reed at 12:41 was already back at John's house. Although Reed did not address a statement to Murrer in a special motion, her reply brief argues that they fall under the second, third, and fourth clauses of that. However, She has failed to establish this in the case. Okay? As explained above, for statements to be reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, they must be directed at an authority that could affect such consideration. The production staff of a documentary film is not such an authority. Motherfucker! The statement were not at the production staff. They were recorded to be publicized to the public and addressing the government's flaws. There is also no plausible argument that statements Reid made to Mueller and her team were reasonably likely to enlist public participation in an effort to affect such consideration. Again, even though they were the ones there and recording it, that was not the intended audience for it. It's as saying, for instance, I make videos all the time. Everybody should go watch them. They are really good, some of them at least. They are interesting and entertaining, at the very least. But as I'm recording it, I talk to Mr. Jingles. Well, no, he's not here. Mr. Jingles is not my intended audience. It's the exact same as the judge is arguing here. If I talk to Mr. Jingles during a video, Mr. Jingles is my intended audience. No, you guys are. This is so stupid. The statements were all made in the midst of Reid's first criminal trial, and in the case of the June 22nd, 2024 statement, 3 days before the jury began deliberating. Because they were part of a documentary film about the trial, Reid cannot have reasonably believed that such statement would be released to the wider public until after the verdict. What the fuck? Are you high or senile? What does that have to do with anything to be released to the wider public until after the verdict? That's a stupid argument. Because the intention was to release it regardless of the verdict. Regardless of the verdict. It was intended to tell the public, tell the government her story. This is so stupid. Oh, sorry. Reid has also not established that the statements were made in connection with an issue under consideration or review by a legislative, executive, or judicial body. It was during her damn trial. How is that not in connection with an issue under consideration or review by a legislative, executive, or judicial body? She's mid-trial, and this judge argues that it has no connection to the ongoing trial. She argues only that the statements fall under this clause because the judicial proceedings were ongoing. Yeah, and intended to publicize that she has been framed in order to pressure the Commonwealth to drop her prosecution and instead prosecute the true perpetrators. Yeah, because she knew they would try again. However, the fact that she was involved in governmental proceedings does not make every tangential statement petitioning activity. Okay, Judge, imagine this scenario. This imaginary reporter, Fetchen Moss, hypothetically made a fuck ton of false statements. Now she is hypothetically sued for defamation. She would be fucked by the same arguments. Do any of you believe a Massachusetts court would hold her liable. Oh no, but in this hypothetical scenario, she is writing for a magazine out of Boston. That must be petitioning to the government. This is why these statements from the judge is utterly flawed. Because whatever he says here should apply to that hypothetical scenario. Which would put any reporter in Massachusetts at risk. She failed to point to any objective indicia demonstrating that her statements to Murray were made to influence, inform, or at the very least reach government bodies either directly or indirectly. This is so stupid. Aiding and abetting claims. The plaintiff asserts claims against Reed for aiding and abetting Kearney's defamation and infliction of emotional distress. Reed contends that her conduct was petitioning activity because it was made in connection with an issue under consideration or review by a legislative, executive, or judicial body. Yeah, she talked to a reporter before trial. And, quote, reasonably likely to enlist public participation in an effort to effect such consideration. Yeah! She again fails to establish the claims had no substantial basis other than petitioning. What? She again fails to establish the claims had no substantial basis other than petitioning activity. Fucker. The first trial didn't happen until 2024, 2 years later. Aidan Kearney didn't start writing about this until a year in. She was trying to save her life. Trying to find people who would talk for her. To get the government to drop the charges. How the fuck is that not? This is insanity. This is insanity. Reed's motion focuses on allegations in the Wanker's motion that she communicated to Kearney non-public information that was in court filings or that was evidence in a criminal trial. Yeah. She does not explain how her providing Kearney, as opposed to the court, with the police report with the plaintiff's private addresses, phone numbers, and social security numbers on it was petitioning activity. I believe they are here referring to the one time Aidan published for a few seconds, which immediately pulled down. To my understanding, that stream was edited, so it no longer shows it. But people were fast to screenshot it. Petitioning activity includes any written statement made before or submitted to a judicial body. Emphasis. Yeah, but do you know what these 3 dots here means? It means it's information omitted. Even if such communication could be considered petitioning activity, the aiding and abetting claims extend beyond these select allegations. See, blah, 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 their paragraphs. For instance, the Wankers alleges that Reed found and enlisted Kearney, an aspiring internet personality with limited reach in the greater Boston area. He had a huge reach locally. He had a huge reach even before this. Long before Kearney's trial. He lived out of it. He lived off of it, his reporting. Then you have reach. So this is just with no journalistic training, editorial standards, or oversight. That is not a requirement. for being a reporter. There's not a single phrase in the freedom of the press statutes or the amendment, First Amendment freedom of the press. There's nowhere it says the person reporting has to have journalistic training. It does not say anywhere there have to be editorial standards or oversight. Nowhere does it say that. Nowhere. Ah, thank you. I have no idea. Okay, 1,000 joules. I'm not sure what that is. Thank you, Jenny. Thank you. I know it somehow translates into real money. I have no idea how. But thank you. 1,000 joules. Yay! I think that's the first ones I ever got. Yay! Thank you. So yeah, this bullshit about no journalistic training, editorial standards, or oversight has no place in a court filing because it's not a requirement under the First Amendment for being protected by the freedom of speech or freedom of the press. Because, as I said many times, freedom of the press literally is freedom of the printing press, not the person operating it. The person operating the printing press, that person's rights are guaranteed by the freedom of the actual medium. You put story in, you print it out and hand it over to a larger mass of people than yourself. That's freedom of the press. Freedom of the press has been clarified as technology moves along. It began with the actual printing press, newspapers, printing press, books. Then radio came. Yeah, radio. Yeah, that's involved. TV. Yeah, TV. Yeah, that's also because it's the medium of which the news are reported through. And when internet came along, YouTube is a medium. Kick, Rumble, X are all mediums under the freedom of the press. You're way out of line here, Judge. Who was seeking attention and money, like every fucking reporter in the world does, and routinely engage in provocation and courted controversy. Yeah! Have you read the fucking paper lately? To publish her false statements, which we know are not false. But still, publishing is a part of freedom of the press. And it's not illegal for a defendant to talk to the press. She then told him that the plaintiffs were responsible for O'Keefe's death, which also the evidence points at, and he broadcast such statements on his blog. Reed's motion does not address how such statements have a plausible nexus to her prosecution. Ja, again. We have a defendant who is now in 2 trials. The jury has said, no, she did not kill John O'Keefe. You have independent experts through tests, through physics. The car didn't hit O'Keefe. O'Keefe wasn't hit by a car. The state's own medical examiner despite the pressure from the DA's office and the corrupt investigators, refused to stretch law more than to undetermined. Indeed, the fact that Reid chose Kearney as an outlet for his statements, knowing he would convey the information in a way that would provoke and inflame his audience against the plaintiffs, suggests that the statements were not meant to influence, inform, or bring about governmental consideration of the issue. What? Again, we have to... the judge in this part has to see the wanker's words as true. But still, you can't go this far, Your Judge. Yeah, this is out of line, in my opinion, way out of line. See Blanchard via blah blah statements to the Boston Globe, a newspaper widely circulated in Boston and throughout the Commonwealth, were likely to reach the decision makers at the Department of Mental Health and members of the public wishing to weigh in on the licensing decision. Yeah, Boston Globe, newspaper. Here we go again. Oh, legacy media. That's okay. That's okay, because lawmakers only read newspapers, because as you know, there is not a single lawmaker in the world, in the United States or in Massachusetts, that are on the internet. This is so stupid. Nor does Reid explain how the content of his statements to Kearney, accusations that the plaintiffs murdered O'Keefe, either directly or indirectly, called on members of the public to appeal to the government on her behalf. What the fuck are we doing then, Judge? Me? Other content creators? Other law tubers? True crimers? Normal people? What the fuck do you think we are doing? We are calling out corruption to have the government fight corruption. Statements with no potential or intent to redress a grievance or directly, indirectly to influence, inform, or bring about governmental consideration of the issue lack a crucial characteristic of petitioning activity. Again, they made Morrissey go public in a video and lying his fucking fat ass off. That is what happened. That is directly influencing the government to lie to the government lied to the people. They kept lying to the people to counteract Aidan Kearney's reporting. And we know now how it went for them. Proctor, discovered being a weak-ass Nazi. Sergeant Good, off he fucks. A lot of cops, gone. Retired, just left the force, or got put on desk duty and stuff. As a direct result of Aidan's reporting. Other claims. The remaining claims against Reid, alleging intentional and negligent infliction of emotional distress and civil conspiracy, all have substantial basis other than petitioning activity. The claims allege that Reid orchestrated a campaign of harassment against the plaintiffs, which including funneling information to Kearney and hiring a private investigator to confront the plaintiffs. Hiring a private investigator to confront the plaintiffs. Do you know what that is? That is the defense checking, fact-checking. Even public defenders, they petitioned the court, we need money for a private investigator. And courts, yeah, Here's money to a private investigator. Private investigator investigates. How? By talking to witnesses. So this judge here, this fucking moron, is now saying that is wrong. For the defense to hire a private investigator to investigate. This fucking judge is saying that is wrong. That she and Kearney agreed on a scheme to defame, harass, abuse, and blah, blah, blah. That she provided Kearney with non-public and confidential information about the plaintiffs. And that she celebrated the destruction of the plaintiffs' reputations while monetizing the publicity. What do you mean monetizing the publicity? Are you talking about us crowdfunding for Karen Reid's defense? We crowdfunded to Karen Reid's defense because the evidence told us she did not do this. The evidence that's not destroyed by the government points towards the people in that house. Reid's motion to not attempt to explain how any of this conduct could be considered petitioning activity. We've been through this so many times now. Rather shows that all the claims are based on Reid's alleged defamatory statements to Kearney, which he contends were all petitioning activity. For reasons stated above, the court concludes they also are not. So the court says, if you are a defendant, you are not allowed to defend yourself through the public. You are not allowed to get your story out. You are not allowed to share your opinions about what the evidence shows. This is what the judge is basically saying, which is insane. Even if we go by the fact that he has to regard the wanker's words as true, this is way out of line for me. Yeah. As Stephen says, the court says you are not allowed to expose the government corruption. Yeah. Because Reid has failed to show her statements and conduct at issue in the plaintiff's claims were in an effort to petition the government for redress of harm, she has not carried her threshold for burden for an anti-Slapp motion. Yeah, according to the court, if you are a defendant, you talking, because she's already addressing the government in court. So addressing the government corruption outside of court is suddenly not valid, according to this judge. The court therefore need not to proceed to the second step of the analysis, and the challenge claims will survive. Order, both are denied. Judge Mark C. Gildea. Or Uncle Bev. Yeah. Remember, one of the first things that was known was said by these wankers and Proctor and Buchanan. I hope she pleads or it's going to be a mess. That was the words. They went after the wrong person because Karen Reid had resources. Karen Reid got a good attorney to begin with. And despite remember all the money that Karen Reid has spent on her defense, the government has spent 10 times more. even though with all the resources, her team, media, us content creators, we are not even close to the resources the government has. Not even close. And all happened because Karen Reed woke up too soon. She woke up. Where's John? Because John doesn't abandon his kids. She panicked. She enlisted people she knew were there. Carrie and Jennifer and Jen McCabe. We need to find John. If she had woken up 2 hours later, it is my opinion that the House defendants would have blamed Lucky, the plow driver. And Lucky would not have the resources Karen Reed has. We would never have heard about this case if Karen Reed had woken up 2 hours later. All right, folks. That is what I had for you. My somewhat snarky analysis of the court decision. Now, you're perfectly fine telling me I'm an idiot. Tell me where I'm wrong. I'm fine. I'm a big boy. I can handle it. For the replay crew, thanks for watching all the way to here. If you're watching this in the next hour and a half, my slightly bust show starts in an hour and a half, roughly. So get over there. Get over there. You who are here now will be transferred over there, so you can put the thumbs up and do the things, remind me things, so you can be there. I will be there, of course. Mo will be there. And also a brand new guest. Bacon Bears will join me because you guys harassed me. No, you guys made me go over there, watch her, and then invite her. And so she will be here on the Slightly Bust show, and maybe some other guests. And we will be talking about the Karen Reed case, the Reckless Ben case, and whatever comes to mind, with a brew in hand and the Wheel of Regrets. All right, folks. Thank you. From me, Mr. Jingles, even though he didn't make an appearance, I hope he will be making an appearance later. Thank you. Thank you so much for being here. Without you, this here would not be possible. Thank you. Oh, for the 250 joules. And for the 1,000 joules from Terry and Jen. I have no idea what that translates into. But thank you, guys. You all have a good one, and I will see you in an hour and a half. See ya. Bye-bye.
Santa Claus, riding in with the winter laws. Santa Claus.